little bit more about patents now and how the patent work.
Well, one of the most important things to realize about patents is they're not permissive rights, they're negative rights. And what that means is that if somebody gets a patent, it gives you the right to exclude somebody from making, using, selling, offering for sale, or importing that product or performing that process.
Mm-hmm.
And so when you're looking at a patent, there's a section of the Patent Act that is issued called the patent claims. And those patent claims list out the minimal set of elements that somebody needs to have in a product or process to infringe on that patent claim. So the more elements that are listed in the claims, the more things need to be found in an infringing product. So truly less is more.
Yeah, that was my question. So if I just write a generic patent claim, can that mean that I can sue anybody in the world just because, let's say, they use the word yes or something like this?
Well, all right, the US Supreme Court has some very strict guidelines on what can be patented.
Mm-hmm.
In this one case called Diamond versus Chakrabarti, they said what can be patented is anything under the sun made by man.
Mm-hmm.
But those things need to be new, so it can never have been done before. They have to be useful, so you need to get some type of utility. Somebody has to value it, give some type of value to what that new process or product is bringing, and they can't be obvious based on what has been done before.
Mm-hmm.
So if you draft a patent claim in your patent that is not new, then that claim is not valid. If it has no utility, it provides no use to anybody, it's still not valid. And if it's obvious to anybody, it's still not valid. And it's worth discussing what obviousness means.
Yeah.
What the courts have said is, if somebody was presented with the same problem, or not somebody, a very special somebody, a person of ordinary skill in that field. So not the geniuses in the field and not the know-nothings, just an ordinary person in that technology area. If they were presented with the same problem, would it have been obvious for them to come up with the same solution without undue experimentation? So if they saw the problem, could they work a little bit on it and come up with the same solution relatively easily?
Mm-hmm.
But if it would only be obvious to a true luminary in the field or a guru, that's not the standard that we're looking at. And oftentimes in patent litigation, the two sides will be arguing over who is an ordinary person. One side will be saying the ordinary person requires a PhD and 10 years of postdoc experience, and the other one will just say, no, they just need a high school degree and have taken one class in physics.
Yeah.
And so, and then the court and possibly a jury will come to a decision as to who is a person of ordinary skill in the art.
One particular question right now, because people in the court and the jury, they are not technical people.
Right.
How that works? Because if we put highly technical people who are arguing who is technical enough to be obvious or not technical enough to be the obvious person, how they make this decision? So
that's part of the skill set of a good trial attorney, is to be able to take these complex concepts and to distill them down into a story that non-technical people can understand. And so they will bring technical experts and expert witnesses to the stand and have them express their opinions and then convey those opinions back to the jury, and then the jury needs to compare and contrast. And so their job is to assess the people and the witnesses and see which one is more believable than the other, and see, so if one group of witnesses on one side end up contradicting each other and they can't get their story straight, that's really what the jury is going to be judging, not necessarily the technical merits of the witnesses.
How to file a patent?
So you don't need an attorney to file a patent. Anybody can file a patent. However, it's a little bit like going on to a long journey across the ocean. It's easy to get off course if you don't have a navigator and you don't know what you're doing. So most good patents are written by patent attorneys, since we're used to taking these journeys. When working with our clients, we'll start off with a detailed disclosure meeting. The only thing the inventors need to bring to that meeting is a good understanding of what their invention is. And we'll sit down in a conference room like this and start talking and writing on the whiteboard and really investigating what the invention is, and then giving scenarios to the inventor to say, well, what about this? Have you considered these options? Trying to figure out what are the components that we want to be putting in the claims. And we need to figure out also what was in the prior art, based on what the inventor understands, had been around. And there's going to be a problem that they're trying to solve. And it's a problem that the prior art wasn't able to solve. And so we need to figure out what are the things that they've added that are new, useful, and not obvious over what was there before.
Well, maybe if I ask you for advice, if there is a new startup and they invented something, and they want to file a patent for that, what things they need to prepare before they meet for the first time with you?
Really, they just need to understand their invention. They really don't need to do anything in advance. I mean, there's a little bit of paperwork with us. We'd like to sign an engagement letter with the client to make sure that we have an attorney-client relationship, because they're going to be telling us some of their most secret and most important information about their product and their company, and we want to make sure that we have an attorney-client relationship so it's clear that that information is confidential.
What about, for example, can they do some investigation what other companies are doing in this area? Or because I hear sometimes this is not the right way to do it and you can fall into some traps there.
So doing investigations is a two-edged sword. So we like to have a conversation first. So before a patent issues, it doesn't have a presumption that it's going to be valid. After a patent issues, it's presumed that the patent is valid. And so if you do a search afterwards, it's presumed that the patent office did their job and also searched, and that the patent will stay valid. But if you do a search before the patent issues, there's a rule called the duty of candor that we have with the patent office that requires us to share the results of any search with the patent office. And sometimes very thorough technical people can do a better job at searching than the patent office. And they may not find something that would prevent them from getting a patent, but they may find material that will delay and increase the expense of the process of working with the patent office, because there'll be all these pieces of prior art that now need to be addressed and that the patent examiner may use against you.
Do I understand right that actually the less investigation I do around, let's say, my invention is better? Or
on the flip side, if you've done the investigation, now we can draft the patent with the awareness of these other pieces of prior art and do a better job drafting the patent. So usually what I'll recommend with my clients is don't do any searching till they meet with us, and then we have a discussion over what's more important to them, to reduce the cost and get as broad of a patent application through as possible, or to have a more tailored and focused patent application that navigates through all the patent search documents and results that we've come up with. And it's worthwhile having a strategic discussion about what's going to be more cost effective or better business sense for the company. Oftentimes with larger companies, they'll specifically say don't do the patent searching, because the overall increase in cost to get patents for the whole portfolio will be more expensive than them losing, so we say 10% of their patents because they were drafted too broadly. And so it's a balancing test that's, again, good to talk to your patent attorney first.
Okay, I understand. I think we are running out of time for this segment, but I wanted to get two more questions in it. So one is, you said the patent will cost between $20,000 and $30,000 throughout the life of the patent.
Right.
My blunt question is, can startups afford patents?
So for the filing process for a full non-provisional patent application, it's going to be about $13,000 if you're using our firm. But we can also file a provisional patent application, which is only $5,300 if the attorneys draft it, or we can even coach the inventors through and keeping them on course and do a coached provisional patent application for around $2,500. And so we can use tools to defer out the larger expenses for a year or more to allow the startups to either get funding or build up some revenue that would then allow them to make the bigger investments. But we can preserve that intellectual property using the provisional patent application process early on. And also, it's not the full $30,000, it's only about $13,000. And then there's probably 2 to 3 years before any further money would actually need to be spent on that patent application. So it's not quite as big, but the total process is about the $25,000 range.
And very briefly, can you explain what is provisional patent and how it works?
So provisional patent is about 2/3 of a regular patent application. You still have the drawings and you still have a detailed description, but you don't have the claims portion. And they're a little bit less formal on what types of drawings and detailed description need to be filed. So it's a lower cost placeholder that lets the patent office know that you are in possession of your invention. You file it with them, it's given a patent application number, and you can now call your patent, your invention patent pending. But it only lasts for 1 year, at which point it either expires or you need to file a non-provisional, the full utility patent filing that would then proceed with the full patent process.
Okay, great. Let's wrap it up like that.
Sounds good.